Good morning, everyone. I request you to please take your seats so we can commence today's event. Good morning, everyone. It is with immense pleasure and honor that I extend a heartfelt welcome to the chief guest for this event, Honorable Justice M.M. Sundaresh, Judge, Supreme Court of India, and guest of honor, Honorable Justice S.S. Sundar, Judge of the Madras High Court. We are honored by the presence of many sitting and retired judges, tribunal members, as well as senior advocates. We also extend a warm welcome to all our co-authors, 40 of them, family, friends, colleagues, and well-wishers who are joining us today. Today we are gathered to celebrate a milestone that marks the culmination of hard work and shared academic curiosity for resolution of commercial disputes. It is my distinct pleasure to invite and welcome all of you to the release of the book, Commercial Dispute Resolution, State of the Law in India, a collection of topic-based chapters penned by the present and past lawyers of AK Law Chambers, with Anirudh Krishnan as the chief editor. As we gather here today, let's take a moment to reflect on the remarkable journey that has brought this book to life. The path began about a year ago at the 10th year celebration of AK Law Chambers, when Anirudh told me and a couple of others that he had this idea to write a book on the topic of commercial dispute resolution and that there wasn't one such in the market. His idea was to involve the current and past lawyers of our firm, and this was the spark of inspiration. I must mention how willingly each and every one of them came together without a second thought. Countless hours of research, writing, editing, and perfecting followed. Each page crafted with due care, dedication, and rigorous research. The book embodies each author's unique voice and thought process. We begin today's event with the lighting of the lamp. I request Anirudh to please accompany our chief guest and guest of honor to light the lamp. Thank you very much. I now request Anirudh to accompany the chief guest as a guest of honor to the dais. We begin today's event with a prayer. I'd now like to invite Mrs. Radhika Krishnan, who is the co-author of the author, to recite a poem.
Thank you, Goda. Morning, ladies and gentlemen. We are assembled here today to commend a wonderful feat by Anirudh and his 40 associates. Do I sound as though I refer to Alibaba and the 40 thieves? No, it's Anirudh and his 40 associates. And this would not have happened but for the grace of God. So as we bow our heads in gratitude and obeisance to the Lord above, here is an inspirational paragraph from Sri Rabindranath Tagore. Face to Face by Sri Rabindranath Tagore. Day after day, O Lord of my life, shall I stand before Thee face to face? With folded hands, O Lord of all worlds, shall I stand before Thee face to face? Under Thy great sky in solitude and silence, with humble heart, shall I stand before Thee face to face? In this laborious world of Thine, tumultuous with toil and with struggle, among hurrying crowds, shall I stand before Thee face to face? And when my work shall be done in this world, O King of Kings, alone and speechless, shall I stand before Thee face to face? Thank you.
Thank you. That was a very thought-provoking beginning to the event. I'd now like to invite Anirudh, the chief editor of the book, to share a few words about the book, its contents, and how it came to be.
Thank you. Good morning to one and all, the Honorable Justice Sundesh, Judge of the Honorable Supreme Court of India, Honorable Justice S.S. Sundar, Judge of the Madras High Court, so many of the learned sitting judges of the Honorable Madras High Court, so many of the retired judges, Chief Justices and retired judges of the Honorable Supreme Court as well. This has been senior advocates, friends. This has truly been an overwhelming experience for me. I have been overwhelmed at many levels, to start with the presence of so many dignitaries today and the number of people who have come here. I'm truly overwhelmed. I must start with the dignitaries on the dais. I think when it comes to one common thread that cuts through both the learned justices on the dais is that anybody who goes for a hearing in their court will come back satisfied that they have been fully heard. Whether it is a youngster, whether it is a senior person, I don't think it makes any difference. And I must say that for me as a youngster, appearing before His Lordship Justice Sundaresh, I might have bored him endlessly, but in my early days, I think some of my long hearings were before his lordships, and he tolerated me on multiple occasions. And I think as a youngster, the confidence that instills is something phenomenal, that somebody is willing to give you such a long and patient hearing. Similarly, before his lordship Justice Sundar, the early days I did not have much of an opportunity to appear, but whenever I've always had a full hearing and a lot of encouragement from his lordships. So thank you very much to both the dignitaries of the dais for so readily agreeing to be chief guests and the guest of honor today. I must also say that when I approached his lordship Justice Sundaresh and requested him to write the foreword for this book, he was so willing that also left me overwhelmed. I think the lesson that it teaches all of us is that whatever height one reaches, simplicity and humility is the key. The other person I must thank is Mr. Gary Bone, who was supposed to join us through video conference but has now not been able to join because he had an emergency arbitration hearing. So he has sent us a video clip instead. He is also somebody who, despite being one of the legends in the field, being the author of the leading commentary in the world, was very happy to immediately accept my request to write the foreword for the book. So he is again somebody who I think embodies the virtues of simplicity and humility. And I must thank him as well for so readily agreeing to write the foreword. When I said it's an overwhelming experience, I said it's on many counts. One is today. The second is the experience itself. Now, when a few of us were sitting, 4 or 5 of us, and we were thinking about some of the topics that we had researched on and said, why not try and convert all of this into a book? And since it had all been a collective effort of researching on these topics, I thought it should be a book involving all my colleagues. So I sent a message on the WhatsApp group of current colleagues who work with me and the ex-colleagues, saying, this is an idea, would any of you be interested in joining? I had 40 responses. That was truly overwhelming. For me, at the end of the day, this book was not just about writing it, but about bonding with the entire team through the process. And I must say, I have learnt a lot from all my colleagues through the process. Broadly about the process, we then realized that, all right, some of these topics were all around commercial dispute resolution. Some of them were on arbitration, some of them were on the Insolvency Code. There was some work on the Commercial Courts Act. Then we thought, why not look at commercial dispute resolution as the topic? So we decided that, well, post-2015, and all this research was post-2015, most of it. 2015 was a marquee year when it came to commercial dispute resolution in India. You had the arbitration amendments, you had shortly after that you had the Insolvency Code, and then you had the Commercial Courts Act, and these have really changed the face of commercial dispute resolution. But as with any new legislation, there will be a lot of teething trouble, there will be interesting legal issues that arise. So we thought, why not use these 3 as the base legislation and see how the law has developed. So we picked out about 30 topics of which in relation to certain grey areas on these 3 subjects. In addition, there were about 10 other general topics that we keep coming across, like how does one construe an exclusion clause, how does one construe trade secret protection. So you had multiple other general topics of great interest. So we thought, all right, let's include this, make it 40 topics, and now that we have so many people who are keen, let's split the topics between each of them, and some of it I co-authored, some of it are all written by colleagues of mine. Thereafter, we had an editing process. When the editing process was, we had a team of 6. So I went through the drafts once, and I had a team of 6. Adarsh Subramaniam, Ram Kishore Karnam, Adit Narayanan, Pranay Prakash, Sriram Venkatavardhan and Sai Sudarshan, and we split the topics between them for a second round of review. And we were also, through this process, the person who played the role of sheet anchor was Rupika Srinivasan, who had a very critical role because she ensured that, so we all looked at it topically, she looked at all the topics. So at the end, and she was assisted by Nivedita, who joined us then as an intern, but did work that was far, far more than what one can expect from an intern. With all of this, we then realized that, all right, there were some topics that could be controversial. We had taken a position in relation to some case laws and some the march of law in certain regards, and we thought, all right, all of this, before we publish it, let us make use of the in-house expertise in the family. So we approached Honorable Justice R. Subramaniam, who is Adarsh's father, and my father and father-in-law, M.S. Krishnan, Senior Advocate, Mr. K.G. Raghavan, Senior Advocate, and Sriram's father, Mr. Venkatavardhan, who is an expert in IBC. And we requested them to review what we thought were controversial topics, so we get the nod from them before it goes ahead. I must say that they took out so much of time from their busy schedules to aid us in this process, and we are deeply indebted to all of them. And I must also say that I've also had multiple discussions on these topics independent of that with my father and my father-in-law. So after all of this, the book was in some shape. We had a detailed review, a detailed proofreading exercise by my mother and my wife, and there were also one more round then finally by Rupika before we were ready for publication. Coming to publication, I must say how readily LexisNexis agreed to publishing this book. Mr. Arjun Bhargava is here. He did not bat an eyelid. He straight away agreed to publish it. Therefore, in the end of it, it was a very, very fulfilling exercise. Finally, before I end, a few words about my family and the support that I have received from them. I think in all of this, the sufferer is the family, because you end up compromising on the time that you spend with them. And I must say that my wife Goda and my children Adrit and Shreyas have stood like pillars, and my parents have been such a huge support. I think but for the sacrifice that my mother made, we could not have even dreamt of such an exercise or getting here, and but for the sacrifice she made, she would possibly be either a senior advocate or a judge today. So I think that sacrifice is immense. And my father has always been a mentor both personally and professionally. A lot of these, in addition to the general mentoring, I must say that a lot of these topics began at the dining table, where we would discuss some of these topics. The rest of the family would say that you don't discuss law all the time. But I must say that a lot of those topics began there. And my father-in-law has also been a great support. A lot of these topics were also discussed with him. And therefore, I think but for my family's support, I don't think we'll be here today. Finally, I'm sure there will be errors in the book. I take entire responsibility for that, and if there's any criticism, any suggestions where we can improve for the next edition, please do let me know, because we hope to work on it as an ongoing project. Thank you very much.
Thank you, Anirudh. I often joke that when you look at the book and the way the chapters are arranged in it, the chapter at the very end, which is titled Mitigation of Commercial Disputes by Drafting Contracts. That has been co-authored by me because I work on the corporate side. And I tell him that if we had placed this chapter at the beginning of the book, maybe the rest of the book may have been redundant. I often hear this saying, this document is very loosely worded. As Anirudh said, I'd like to invite 3 key members of this team, Adarsh, Adit, and Sriram, to speak about 3 individual parts of the book. I call on stage the 3 of them. Adarsh.
A very good morning to one and all. A very good morning to one and all. It gives me great pleasure to address this August gathering today. A day when the cumulative hard work of about 40 of my colleagues, led by Anirudh sir, sees the light at the end of the tunnel. While my colleagues will deal with the other aspects of the book, I am here today to speak about the chapters in the book that delve deep into the waves caused by the introduction of the Commercial Courts Act. We have placed a dedicated chapter that provides an introduction into the contours of the enactment, highlighting the importance and benefits of the procedures that it has set in motion. The introduction of pre-suit mediation and the views taken by courts across the country, and finally the Apex Court as to the mandatory nature of the provision, the need for specific denials in written statements and the effect of its absence, and the importance of filing admission and denial of documents, and the effect that it would have in reducing the time taken in concluding a commercial suit have all been highlighted. These apart, the procedures set out for discovery and interrogatories during the pendency of a suit have been dealt with in great detail. The differences in document request procedures between the CPC, the Commercial Courts Act, and the practices that are prevalent in the arbitration circle have all been set out in great detail as they set out the emerging trends today, and the benefits of following such procedures are also highlighted, which would enable any litigant or a lawyer to attempt to cut short trial and to take a matter to its logical conclusion at the earliest. Special emphasis has also been placed on the role that an application for summary judgment would play in shortening commercial litigation. The key differences and similarities between an application seeking summary judgment, between an application seeking judgment upon admission, and a summary suit have all been set out in great detail. And certain illustrations have also been provided for to showcase the different scenarios in which each of these provisions can be made use of to their best extent possible. And apart from this, the process of issuing summons to parties outside the country and the procedure to prove various kinds of electronic records have been specifically set out in independent chapters because, as we all know, the world is shrinking and going digital as I speak. The much debated issues of review and appeal of orders passed in commercial suits and the various questions that have been posed in this regard by courts across the country, including our Supreme Court, and the variety of answers that we were able to find both in Indian and foreign jurisprudence have also been set out and highlighted so that one is able to understand what is the next course of action that is available to a litigant once an order is passed by a commercial court. Finally, as the icing on a cake, an illustration-filled chapter discussing the interplay between all of these provisions and the different facets of a commercial suit and the various opportunities the enactment poses both to the bar and the bench to have various weapons in their armory on how a commercial suit can be shrinked or finished at a pace that is in tune with the objects of the Commercial Courts Act has been put in place, because without such a chapter, this entire part of the book, which focuses on how a commercial suit can be finished in a time-bound manner, will not have much relevance. We hope that this book brings all of you the same joy and enlightenment that working on it has brought us. Thank you very much. I invite on stage my dear friend and colleague, Adit Narayan Vijayaraghavan, to say a few words.
Respected judges, senior advocates and mentors, fellow authors, esteemed colleagues, and my friends. It is a privilege to stand before you today as a co-author of this comprehensive work on commercial dispute resolution, state of law in India. This book encompasses the current state and evolving landscape of commercial dispute resolution in India, particularly focusing on issues arising within the alternative dispute resolution regime. Part 2 of the book dwells into several crucial hot topics that shape the practice of alternative dispute resolution in India. We begin by exploring whether pre-arbitral procedures are mandatory or merely directory, a question that often dictates the course of arbitration. We then examine the plight of contractors facing accepted matters, a complex area where specific contractual clauses can become a nightmare to the litigants. Next, we analyze the court's power under Section 11 of the Arbitration and Conciliation Act, a contentious issue where the balance between judicial intervention and the autonomy of arbitration is constantly debated. We also examine the ongoing debates between the Arbitration Act and the Stamp Act, focusing on how stamp duties can complicate the arbitration process. Further, the question of bias in arbitration, as elucidated in Schedule 5 of the Arbitration Act, is also dwelled into. Additionally, we tackle the critical issue of excessive fees in arbitration, a concern that often leads to dissatisfaction amongst parties and an elongated litigation process. We also navigate a very complex terrain of seat, venue, and exclusive jurisdiction, concepts that, while intended to provide clarity, sometimes creates more confusion. This is further complicated when importing the concept of seat into domestic arbitrations, leading to significant challenges. Further, the book examines the fine line between modification and severability in contracts and how these principles are applied in the arbitration. We also advocate for third-party fundings in Indian dispute resolution, recognizing its potential to democratize access to justice. Finally, we also decode the Mediation Act 2023, pondering whether its introduction is premature or necessary evolution in the dispute resolution framework. And I thank you for your patient listening. I hope you all enjoy reading the articles of the book. And now I invite Mr. Sheena Mikatavardhan, my friend, to deliver his speech on insolvency and bankruptcy code.
A very good afternoon to the Honorable Supreme Court Judge, Honorable Judges of the Madras High Court, senior advocates, members of the bar, friends and family. Before I actually start discussing about the book, I would like to enlighten the audience briefly about the prelude to the book, in fact. So when AK had initially floated the idea of writing this book, we were all more than thrilled to be contributing to this book. But the real catch came thereafter. And AK, after receiving our responses, went like, guys, this is going to be a hard deadline and we have to complete this book within 8 to 9 months. So we realized that there is going to be a very tight deadline set on us. And at AKLC, we colloquially refer to these hard deadlines that AK gives us as the deadly deadlines. So it was nostalgic to relive this experience again. So thank you, sir. But jokes apart, if not for, I think, AK's constant push and the grind we had undergone at AKLC, this opportunity of working on this book would not have been possible. So thank you once again, sir. So now regarding the book, I had the opportunity of authoring and co-authoring about 4 chapters on the Insolvency and Bankruptcy Code. So after the introduction of the IBC, as we are all aware, the ground for inability to pay debts as a ground for winding up was eliminated from Section 271A of the Companies Act 2013. So you could now approach the NCLT under Section 7, 9 or 10 for initiating insolvency proceedings against a company when it's unable to pay its debts exceeding 1 crore. So while designing the chapters in this book, we were very conscious of the fact that the book should not be restricted only about discussing the law and stating the law as it is. we wanted to also stimulate further academic discussions on points where we had written about positions against the well-settled principles, so that there could also be a need for a legislative amendment wherever required. For instance, in the chapter pertaining to the need for modification and withdrawal of resolution plan that I got to work with AK and Anisha, we were very conscious of the fact that the judgments were definitely against us. In fact, the Honorable Supreme Court in EBIX had clearly disallowed the need for modification and withdrawal. But with all due respect to the Honorable Supreme Court, we still felt compelled to write about this topic because we wanted to analyze the jurisprudence from UK and US and also analyze it from the economic implications of disallowing a modification. And secondly, in the chapter pertaining to group insolvency that AK had written with Sai, so the NCLAT had just passed the decision in the region batch permitting the consolidation of CIRPs, but the authors have sought to analyze the current framework of the code and discuss about whether the current framework in fact permits consolidation of CIRPs. One other area that we felt that required highlighting was treatment of contingent claims. So the Honorable Supreme Court and the NCLAT and the NCLTs have taken a decision that permitting continuation of pending proceedings in relation to treatment of contingent claims would be to the inure or would be to the benefit of contingent creditors. But we have sought to analyze these decisions to clearly demarcate as to whether such continuation would in fact inure to the benefit of contingent creditors, and we have provided reasonable suggestions that we felt could be useful. So, being a book on commercial legislation, we have tried to be as exhaustive as possible and culled out all the topics that we felt would be relevant. And while the jurisprudence in IBC is constantly evolving, that too on a day-to-day basis, we have tried to be as exhaustive as possible even with the legal position. So we genuinely hope you guys find the book useful, and I thoroughly enjoyed working with all my co-authors, including AK, Sai, Advait, Mohit, Abhishek and Anisha. So before I conclude, I would also like to express my sincere gratitude to Honorable Justice R. Subramaniam, MS Krishnan sir, KG Raghavan sir and my father R. Venkatavardhan for guiding us and providing their constructive criticisms on the book. So thank you very much.
Thank you, Adarsh, Adit and Sriram. A common name in the field of arbitration and the author of several books which are authorities in arbitration is Mr. Gary B. Bond, the partner for the International Arbitration Practice Group at Wilmer, Cutler, Pickering, Hale and Dorr LLP. When we met him this summer, when Anirudh and I met him this summer in London for the London International Disputes Week earlier this year, he very graciously and willingly agreed to write the foreword for the book. He also had agreed to join us today over a video call to address the gathering. But due to a hearing before the emergency arbitrator, he was unable to do so. However, he has sent us a short video recording and we will play it for you right now.
Sincere apologies that I could not be with you today in person for what I have no doubt at all will be an exceptionally successful book launch. I can tell this distinguished audience how exciting a place India has become in recent years as a location for cross-border international business. Business in India is on the rise, and so are cross-border transactions with some sort of nexus to India. A decade ago, India was the 9th largest economy in the world. Today, the 5th largest. India is slated to climb 2 more positions in the next 3 years to be the 3rd largest economy in the world with a cumulative gross national product of more than $5 trillion. India's growth story has been exciting, not only for India, but also for the rest of the world. But like everywhere else in the world, business, commercial transactions inevitably bring disputes with them. And as a consequence, a book like the one that we are launching today, Commercial Dispute Resolution, State of the Law in India, that focuses on resolving commercial disputes in India is exceptionally timely. This book does a commendable job traversing the various issues that arise when resolving commercial disputes relating to or in India. The authors recognize the problems that have historically led to delays in resolving such disputes in Indian courts. They discuss the various steps that have been taken specifically since 2015 by India's lawmakers and courts to reduce these delays. The issues that have arisen from those various reforms, changes to India's legal regimes, and the issues that still remain despite the various reforms that have been undertaken. The book touches upon topics that are most relevant to resolving commercial disputes in India today. The issues with India's ADR, its Alternative Dispute Resolution Regime, issues arising out of the enactment of the Commercial Courts Act, and issues relating to India's insolvency and bankruptcy regime. Various chapters of the book helpfully contain a comparative analysis, making it an especially useful tool for both Indian but also international practitioners like myself. The book contains as well suggestions on improving the resolution of commercial disputes in India going forward in the future. I personally found that chapter both extremely interesting but equally helpful. Needless to say, I thoroughly enjoyed reading this book, and I'm very sure that each of you will as well. I again congratulate the authors on this accomplishment, their accomplishment, and I'm confident, very confident, that this book will be an important resource for both courts and practitioners, businesses and students and their law professors and anyone else with the slightest interest in the field. Heartfelt congratulations again, and my very best wishes for a successful book launch. Thank you.
Our guest of honor, Justice S.S. Sundar, graduated from the Madras Law College in 1987. Hailing from Tuticorin, he began his practice at the Madras High Court under the mentorship and guidance of senior advocate Sri T.R. Rajagopalan, after which he practiced independently before the Madurai bench of the Madras High Court. His practice area have been civil appellate side, service and writs. He has been a panel advocate for the Madras University from 1996 to 2001, the National Textiles Corporation, amongst others. He was also the General Secretary of the Madurai bench of the Madras Bar Association from April 2008 to March. He has also delivered several important judgments, such as the M. Kadirvel versus Inspector General on the interpretation of the provisions of the Registration Act, Sun Pressings in relation to Employee Provident Funds Act, and the Chennai Petroleum Corporation Limited versus NGT on the exercise of powers by the NGT. I invite on stage Mr. K.G. Raghavan, Senior Advocate, Karnataka High Court, to present a memento as a token of our appreciation. I now invite Mr. M.S. Krishnan to present a memento to our chief guest as a token of our appreciation. I now request Honorable Justice S.S. Sundar to share a few words.
Good afternoon to everyone. I'm a little bit nervous because public speaking always actually next to death. I'm really delighted to have this opportunity to share my thought in appreciation of this book, Commercial Dispute Resolution. First of all, the making of this book involving many young members of the bar is an unique feature, and that tells us the power of collaboration and the strength of a united team of authors. Honestly speaking, I have not yet read the entire book, but the topic which has been carefully chosen, and each chapter gives an impression that this book is going to be very useful to the lawyers community, and of course it is also to the judges. This book is a brilliant and smart work of young minds showcasing the literary excellence of authors and dedication of the whole team. The release of a book really is an important event for me because it is the first occasion for me to participate in one of the functions. And I'm just actually amazed by the legal expertise, the profound commitment to a thorough research and innovative thinking of the young members, of course the colleagues of Mr. Anil. I really thank them for their contribution to the legal fraternity. This book is the result of countless hours of diligent work, deep analysis, and collaborative effort. And I have to, now I don't find words, of course, to comment on their every one of the individual's contributions. It represents more than just a collective effort, but the power of teamwork, intellectual rigor, and dedication. Of course, I have to share this with every one of you. This book is reading of the book. I'm sure that it will give you an enriching experience. It has broadened my understanding. Of course, when I read actually few chapters, it has really broadened my understanding of importance in alternative dispute resolution mechanism and solving current issues in commercial disputes. And I have found myself inspired by your perspective and insights. Your ability, I am actually talking about the authors, your ability to communicate complex ideas in such an accessible and engaging manner speaks volumes about your skill and passion for the subject. Each chapter reflects the collective knowledge, diverse perspectives, and relentless pursuit of excellence that you as a team have brought to this project. This undertaking is more than just a collaborative writing project, it's an example of professional unity. In the field of law, where precision and clarity are paramount, your book stands as a beacon of thorough research and thoughtful scholarship. It serves as a valuable resources resource not only for legal professionals but also for anyone seeking a deeper understanding of complex legal issues. Releasing this book is not just a milestone, it's an opportunity to impact the legal community and beyond. Your work will inform, challenge, and inspire others, contributing to the ongoing dialogue and development in the field. As they write this book, they are not only creating a valuable resource but also strengthening the bonds of comradeship where within the office. This shared effort will undoubtedly enhance their professional relationship and foster a culture of mutual support and growth. Michael Jordan, talent wins games, but teamwork and intelligence will championship. I refer this book, I remember always this book for the great efforts of the team. The journey of creating this book has involved meticulous research, thoughtful analysis, and a deep understanding of the legal and business implications of commercial disputes. It reflects the collective expertise and dedication of your team, blending individual insights into a cohesive and impactful resource. Your combined expertise and commitment have resulted in a publication that will not only educate and inform, but also drive meaningful change in how commercial disputes are managed. To the young lawyers who are the co-authors, I really congratulate every one of them for your successful launch. As we celebrate this achievement, remember that your good and collaborative spirit, shared expertise, and unwavering dedication that made this possible. This book is a powerful reminder of what a united team can accomplish, turning meticulous research and shared knowledge into a resource that will benefit many of the fraternity legal community. Today we celebrate the release. Let's also celebrate the spirit of comradeship that made it possible. Your collaboration has not only produced a valuable resource, but also set an example of what can be accomplished when colleagues unite with a shared purpose and mutual support. Congratulations to each and every member of the team of Mr. Anirudh Krishnan, and I'm really, with your heart, I'll not say hard because I'm a person known for my hard work, but at least the smart work made every one of you actually a little more than the spirit in which I used to spend. Therefore, I really congratulate for every one of your contribution. And here is to your hard work, your success, and the bright future ahead. I conclude my speech. Thank you very much.
Thank you, sir. I think the quote from Michael Jordan was truly very inspiring. Thank you very much. Our chief guest for this morning, Honorable Justice M.M. Sundaresh, Judge of the Honorable Supreme Court. He needs no introduction to the audience here. In any event, he has completed his BA degree from the Loyola College, Chennai, and BL degree at the Madras Law College. He enrolled as an advocate in the year 1985 and has worked as a government advocate between 1991 to 1996. He was appointed as the additional judge of the Madras High Court in 2009 and confirmed as a permanent judge in 2011. He was functioning as the president of the Tamil Nadu State Judicial Academy at the time of elevation. He was elevated as Judge, Supreme Court of India on 31/8/2021. Some of the landmark judgments that he has authored include the MBL infrastructure on the interpretation of Section 29A of the Insolvency and Bankruptcy Code, Trivitron on the trade secrets protection, Texco marketing on construction and enforceability of the exclusion clauses, to name some of the few. I now request Honorable Justice M.M. Sundaresh to please share a few words with us.
A very good afternoon to everyone present here. Sri Anirudh Krishnan and his team, the heroes of the function, including Adarsh, Adit and Sri Ram. My good friend S.S. Sundar, Mr. Gary G. Bond, whom I desperately wanted to meet, arguably one of the best brain in the international commercial arbitration. Justice Khalifullah, former judge of the Supreme Court, my dear brother and sister judges, both past and present, senior advocates, members of the Anirudh's team, senior advocate Krishnan, my good friend Radhika, young lawyers, members of the family, and other distinguished invitees. A very good afternoon once again to all of you. There is an interesting similarity between certain human beings and books. For some of them, their cover will deceive you and their content will surprise. The book, authored by Anirudh and his team, doesn't surprise us because it is brought out with graphic detail and with adequate analysis of the entire spectrum of commercial dispute. Therefore, my hearty congratulations to Anirudh and his team. This is what a group of young minds can possibly do, which even people like us cannot even think of. Radhika, in her speech, I call her up because she is my good friend and our classmate, was trying to draw a parallel between Alibaba and Anirudh. There is indeed a loose connection. Apart from the 40 associates, what connects is the economy. If you take every event of importance, of significance, and if you consider every relationship, be it from a family to that of a nation, the connecting link is the economy. Now, what do we have it here? And what's happening in this institution? We all know it, but we need to introspect. We are moving away from the traditional and conventional litigation to a predominantly commercial litigation. This is the truth. I want to tell all the young lawyers here, the future lies in the commercial and personal litigation. Now, that is the reason why you would find amendments being made time and again in all the commercial litigation. And it has actually flagged it off. Almost all the enactments, I am borrowing it from him, are works in progress. This includes both procedural and substantive laws. Arbitration Act, Mediation Act, then then the Insolvency Bankruptcy Code. If you take all these enactments, they keep going through various amendments. Even the Commercial Act. Both substantive and procedural laws, they undergo constant changes. There is a constant churning out. An attempt is being made by the government to keep them updated to be on par with the international standards. There are problems aplenty in doing that. Sometimes we would find that we may not have the necessary apparatus to deal with the situation. It's like asking an old man in bed to have suffering from arthritis to run for a marathon without even adequate shoes. But then there is always a constant endeavor to deal with this situation. Now, what is happening as a result is that both the lawyers, litigants, and the court are grappling with different scenarios. With the new amendments, they become new challenges. Lawyers with a conservative mindset, we tend to struggle with the changes. And same applies to the court also. Now, if you look at the entire spectrum, the objective behind the book, you would find that thrust is being given, especially in the arbitration, on the party autonomy coupled with the role that is required to be played both by the arbitrator and the court. The constant endeavor is to make the court realize about its specified role. Now, Aniruddha has beautifully captured it, particularly with reference to the Arbitration Act. It's an ongoing struggle. The beauty of the book lies in dealing with varied subjects. It does not deal primarily with the Arbitration Act. It goes beyond. It deals with all the other aspects. There are 44 chapters. As my brother Sundar has said, Anirudh was gracious enough to acknowledge all those who contributed to the book. I really appreciate him for duly recognizing the efforts made by the members of his team. Yes. Secondly, it makes a critical analysis, which again Anirudh has subtly placed before you. A book should create the inquisitiveness in us. If you read a book, it should make us to think and then read it again. The quality of a book lies in the impact that it makes on a reader. Obviously, it's a gift of the author to the public at large. A good book is the one which makes us to read again and again and again. This is exactly what this book does. I am not here to praise him. I am here to tell the truth that this book is not a mere book of understanding of the different statute. It actually analyzes the various amendments made, which is quite fine. But it doesn't stop with that. It goes into the various judgments rendered. Now, as a student of law on the commercial side, one would appreciate the judgments, they keep changing. They keep changing. In this field of law, every judgment penned down by either the High Court or the Supreme Court will undergo severe scrutiny. At times, instead of giving a solution, they do create problems. Now let me just take a few judgments which he has discussed in his judgments, in his book. Starting with pre-litigation, the question is whether it is mandatory or directory. Two different views have been taken by both the Bombay High Court and Calcutta High Court. Then, and this comes with a beautiful solution. He says one should take a middle path, conscious of the fact that you cannot rewrite the terms of the agreement. So the idea is to give effect to it. This is again a problem of the court. We tend to go beyond. We have a defined role under the statute. We tend to go beyond, especially while dealing with section 11 and 14, so 11 and 34. Perhaps at times thinking that our jurisdiction is much wide, we tend to keep focusing on the moral side of it at times. And at times breaking the barrier, notwithstanding the rigor that is imposed under the statute. Starting with section 11, and it is beautifully has put it. A controversy has been created, like one of the speakers said, about the seat and venue. Notwithstanding the judgment in Balco, then following the subsequent judgment in Indus, BNS has read Balco and then said, wherever seat is mentioned, it confers jurisdiction to the court. Now, he has dealt with it very nicely. He has said, this is not what has been discussed in Balco, being a bench of 5 judges, which is obviously binding on the subsequent judgments. And secondly, this judgment, not in consonance with the earlier one, cannot be accepted or cannot be looked at as a binding precedent to the effect of effacing or making the provision as redundant, maybe simply section 21A. Wonderful analysis he has made. We should be frank enough to review. That's how the law develops. Then he moves on to 34, and he's given a different perspective again. Numerous judgments they have come. Fundamental principle of law, public policy, what is the scope, what is the restriction that is imposed. He gives us his own reason, which I could gather after considering his discussion on the issue of bias under section 12, where he says schedule 5 read with 14 is not available in some of the situations. Nonetheless, in a given case, it is not wrong to expand 34. That is his perspective he has given. Then coming to Commercial Codes Act, much discussion has been made on section 12A. Again, the judgment of the Supreme Court in particular automation does create certain new problems. The question is as to whether pre-mediation is mandatory or directory, and if not, what is the effect? He gives his own solution, which appears to me it's more a practical and plausible solution. Striking the plaintiff will have a very serious consequence. Somebody might lose the court fee, and it again, reviving the cause of action would be a problem. He says either cost can be imposed, or the concept of washing off can come if you don't raise it at the earliest point of time, or alternatively, during the proceedings it can be done. Parallel can be drawn to the Mediation Act, which again, Leland Hatter has considered in extenso. He has considered the scope of section 5, which gives party autonomy to a mediation, while section 7 mandates a court to refer it for which no consent is not required. It's a combination of all these statutes which make the book a wonderful reading. Then he moves on to IBC code. In IBC code also we have couple of judgments which might give a different opinion. He finds he is in agreement with Vidarbha Industries on the scope of section 7, whether may shall be allowed to continue or shall be read as shall. Then the real controversy, of course, Venkatavadar is there, so on the interpretation of section 53, which he has also dealt with. Rainbow papers have dealt with in a particular way, which has been not found to be correct in the other judgment. What is it? Pachimal, is it? Now, section 53 gives a waterfall mechanism. Indeed, dues for the government, which we call a crown debt, could be read into a secured creditor and as per the waterfall mechanism is an issue. Then after again it discusses it in detail. Solution is simple because the subsequent judgment has taken care of the earlier one and distinguished on two grounds, namely that one was dealing with at the stage of process, and secondly it did not consider in extenso the scope of Section 53. It was considering the sales tax of the Gujarat. This is notwithstanding the fact that the review subsequently was also dismissed, of course on a technical plea. The last one will be, again, Gary Bourne has already dealt with it in some of his books on the role of the third party being a non-signatory in an arbitration agreement. Now, this issue again has been dealt with in extenso by the Supreme Court in Cox and Kings. Judgments are meant to be criticized. Probably Cox and Kings also may give that impression. The one difficulty without making any remarks about the judgment which I feel is that as judges and especially judges of the Indian courts, we have a tendency to expand. We never feel comfortable by restricting our own jurisdiction. Notwithstanding the judgment in Vidya Rolia and others, they keep saying on the scope and ambit of Section 11, giving interpretation to, and then that's a beauty of this book. I would really say the remarkable aspect of this book is that, and it did not stop with our development of law in India alone. He has dealt with the march of law and the law governing different parts of the world. Singapore, UK, USA and Australia, these are the countries he has related substantially. Those countries have followed a different yardstick and they said make it as simple as possible. If you are a third party, just go away from this. See, why do you go into the issue of piercing the wheel, of course, which is again not found to be correct by the Supreme Court. And then you bring it into Section 12, read with Section 7, you come under the definition of party. These are all judicial craftsmanship is what we can say. Anyway. Now lastly, this book has also dealt with certain new areas. That is really remarkable, I will say. What is going to come in the near future? Like blockchain, smart contracts, online ODR, what is called online dispute resolution, and the use of artificial intelligence, which Anirudh was telling me now. These are all the things to come. We are moving towards a different regime. The best part of the book is that Anirudh, after dealing with different aspects, including like what Koda said about drafting of the contract and all other aspects, Evidence Act, as it then was and what is it now. Ultimately, he goes on to give his perspective about all the pressing issues. In his ultimate conclusion, which he termed this as moving forward, that shows the clarity of the authors and his team. I must congratulate all of you. You have made this book as an extraordinary one, not dealing with a particular subject, but all aspects of commercial law in general. You are not stopped with ADR alone. You are discussed, the Code of Civil Procedure has been discussed role of the tribunals have been discussed, role of the courts has been discussed. An extensive job has been undertaken by all of you. This gives us the hope that the legal profession is in the safe hands. Once again, my congratulations to all of you. Thank you very much for giving this opportunity.
Thank you, sir, for that very detailed insight into the book. We now invite you to join us for the official release of the book, Commercial Dispute Resolution, State of the Law in India. We'll call all the authors.
All of them one by one. Okay. Yeah.
We are all here today because of the contributions of all the authors. I would like to take a moment to read out the names of all the contributors and then request Honorable Justice M.M. Sundaresh to please hand over a copy of the book to every one of the author. Please join us on stage for a photograph. I will read the names in the order of seniority. Maitreyi Kandaswamy Sharma, Kirti Kiran Murali, S.S. Kaushik Ramaswamy, Pravarshini Palanivel, Sir, at the end we can actually take one. Take one and then please stand. Come. That's what. Yeah, come down. Yeah, everybody will take one together.
We can take one.
Yeah.
Photograph. Each person can take one.
Yeah. S. Kaushik Ramaswamy. Pravarshini Palnivel, Janani Shankar, Ashwin Shanbhag, B.A. Sujay Prasanna, Hitesh Singhvi, Adarsh Subramaniam, Adit Narayan, Sella Visalakshi, Ram Kishore Karnam, Garima Kirti, Sriram Venkatavardhan, Sai Sudarshan Satyamurthy, N. Shashank Iyer, Pranay Prakash, Shiva Krishnamurthy, Chandni Pradeep Kumar, Akash Loya, Advait Neelakantan, Mahashweta M, Atif Ahmad Nazim, Mohit Kumar, Kritanjali Sarda, Anisha Chandrakumar, Abhishek R, Suhas MS, Aishwarya Vijayaraghavan, Varun Venkateshan, Rupika Srinivasan, Anurag Rajagopalan, Rita Amin, Ananya Krishnan, Vishnupriya Ravichandar, Pragya Vyas, Samriddhi Sangha, Anirudh Ramkumar, and last but not the least myself, Goda Raghavan. Everybody come.
Come this way. Go that side. Come. Can you get one book? Just give it to her. Give her a book. Hey, come and sit here. Now it's a career dana. எல்லாரும் தெரியும். அவளை தெரியும். கோதாக்கு பின்னாடி இருக்காள். Your face is not seen. The tall man behind can come and sit here. He is visible off. Okay. His face is visible. Yes. Yeah, you can sit. You come and sit here. Come and sit. Come and sit. Your book is not. Now you don't have a deadly deadline. There is a deadly deadline for lunch. Very well done.
While we eagerly wait for lunch, we just have the vote of thanks, and then please everybody join us for lunch. Thank you.
Good afternoon, everyone. As we conclude this event, it is my privilege and honor to deliver the vote of thanks. On behalf of Mr. Anirudh Krishnan and the co-authors, I extend my deepest gratitude to each and every one of you being here to celebrate the launch of our book, Commercial Dispute Resolution, State of the Law in India, our humble contribution to the field of commercial dispute resolution. Firstly, I would like to express our profound appreciation to our esteemed chief guest and guest of honor. We are truly grateful to have you with us today. Honorable Mr. Justice M.M. Sunderesh, whose esteemed presence adds immense value to this occasion. Your distinguished career serves as a beacon of integrity and wisdom. Your esteemed role in the highest court of our land and your unwavering commitment to justice is truly an inspiration to all, and even more so personally to me, since I hail from the same town, native town Erode as well. Honorable Mr. Justice S.S. Sundar, we would like to express our deepest appreciation for gracing us with your presence. Your distinct service at Madras High Court and your contributions to the judiciary in upholding the rule of law are deeply respected. We also extend our sincere thanks to Mr. Gary Bond, who, despite being unable to join us in person, has sent us a thoughtful video. Your words and insights shared afar have added great value to our event. We are deeply appreciative of your support and time you took to contribute to this book and the event. The presence of our chief guest and guest of honor not only enhances the significance of today's event, but also underscores the importance of discourse on commercial dispute resolution that this book seeks to advance. Your insights have enriched our understanding of commercial dispute resolution and has highlighted the relevance of this book will potentially have on this field. We are also extremely grateful that judges, retired judges, senior advocates, and members of the bar have taken out their time from their busy schedule to grace us with their presence. A heartfelt thanks also goes to LexisNexis. Your expertise and commitment have played a vital role in bringing this book to fruition. Your support has ensured that this valuable work reaches those who will benefit from it. To everyone in attendance, your support and engagement today means a great deal to us. Your presence here signifies the importance of our book and the ongoing dialogue of commercial dispute resolution. On a side and personal note, I would like to thank Ms. Goda Raghavan, who in my initial days mentored me and taught me certain principles that I still carry with me today. Last, and by no means the least, I would like to thank Mr. Anirudh Krishnan. 3 years ago, I joined AK Law Chambers as a naive first-gen lawyer. He's been a senior, guide, mentor, and a confidant every step of my way. If there's one person I would owe it all to, it would be Mr. Anirudh Krishnan. Thank you once again. Thank you once again to our esteemed chief guest, guest of honor, judges, retired judges, senior advocate, advocate general, members of the bar, to all our authors, to all our supporters, and to each one of you making this event truly special. I'm extremely grateful to have been given this opportunity to address this crowd. I wish you all a wonderful day.
Can we request Anirudh Ramkumar to sing the national anthem, please? And we'll all.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा इंद्र हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जाहे तव शुभ आशीष माहे गाहे तव जय धाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे